Footage just surfaced of Pooh Shiesty going at his own father inside a courthouse. And the internet has completely lost its mind. The clip is everywhere right now. The father is alleged to have co-designed the entire operation. The case is already cracking at the seams. Big 30 walked out of his bond hearing, and the internet is going crazy over a photo of Pooh Shiesty at 11 years old wearing an ankle monitor. The same ankle monitor the government now says he was wearing when all of this went down. This story runs deeper than any one courtroom clip, and we are getting into every layer of it today. Let's get into it. The moment that footage of Pooh Shiesty and his father in that courthouse began circulating, the internet split into two camps instantly. One side saying Pooh had every reason in the world to snap, the other side saying he should have kept it together, that the courtroom is the wrong place, that you do not give the prosecutors anything extra to use against you when you are already staring at a potential life sentence. Both sides are having the wrong conversation, because the question is not whether Pooh Shiesty should or should not have reacted the way he did. The question is what his father actually did. And once you lay that out in full, once you understand the full scope of what mob boss is alleged to have put in motion and what he walked away with, the footage stops being a question of impulse control and starts looking like something else entirely. Lontrell Williams Sr., known throughout Memphis as Mob Boss, who helped shape his son's identity from childhood, who ran Mob Ties Records, who was the OG that Pooh has credited publicly with teaching him how to move in the world, is named as a co-defendant in the federal criminal complaint filed in the Northern District of Texas. Not as a witness, not as a person of interest, as a defendant, charged alongside his son with conspiracy to commit kidnapping, and armed robbery stemming from the alleged January 10th, 2026 incident at a Dallas recording studio. And the role the government says he played in that alleged operation was not peripheral, it was central. FBI and TBI agents hit a home registered to Lontrell Williams. That is both of them. Father and son share the name, share the address, before 5:30 in the morning with flashbangs, with shouted commands, carrying boxes out into the early morning light. And from the moment the criminal complaint was unsealed, the picture it painted of Williams Sr.'s alleged role was damning in a very specific way. Not because it put him in the recording room with a weapon, but because it allegedly put him everywhere else. Every logistical step, every planning decision, every phone call and vehicle and piece of paper that the prosecution says proves this was premeditated. Williams Sr. allegedly called the Dallas studio owner multiple times in advance to book the session under the false pretense of recording music. He allegedly rented the vehicles that carried the group from Memphis to Texas. He allegedly drove to a Staples office supply store in Frisco, Texas, on the way to the studio before anyone set foot in that building, and printed the contract termination paperwork, the document that prosecutors say was the entire motive for the alleged operation. He printed it, and then his son allegedly held a gun to Gucci Mane's head and made him sign it. Charleston White, one of the few people in this entire conversation saying the quiet part loud. The father drove to the store. The father printed the paper. The son allegedly held the gun. And when federal agents rewound every piece of surveillance footage from the Staples to the studio to the hotel, the paper trail they assembled put Mob Boss at the center of the logistical architecture of the entire alleged plan, which means that by any reading of federal conspiracy law, which does not require you to hold the weapon, only to knowingly participate in the plan, Williams Sr. is facing exposure that is potentially severe. And yet, he got bond. Lontrell Williams Sr. was granted $250,000 bond and house arrest, while his son, the man the DOJ named as the ringleader, the man the U.S. attorney put at the center of the press conference, the man facing the most public scrutiny, sits in federal custody. No bond, no house arrest, no ankle monitor on a couch in Memphis. A cell. And the father who allegedly designed the whole operation, who printed the paper, who rented the cars, who made the calls, is at home. Big 30, who is named as a co-defendant in the same federal kidnapping complaint, got house arrest too, $100,000 bond. Now the father, who got his house arrest in Memphis, is being ordered back to Dallas by a North Texas judge who wants him closer to the proceedings. And Pooh Shiesty, the man named as ringleader of all 9 defendants, remains the one person sitting in a cell while co-defendants on both sides of him are navigating bond hearings, ankle monitors, and lawyers filing appeals. That image, that specific, concrete, documented disparity, is what the internet looked at and said, the son went to Dallas with his father, and he came back alone. That is the betrayal the internet is reacting to. Not just the legal category of cooperation, the outcome, the result. Because in the streets, and in the court of hip-hop public opinion, when you and your father go to Dallas together and you come back in different situations, when he walks out of the bond hearing and you don't, that gap does not go unnoticed. And it does not go unfelt, especially when Lontrell Williams Sr. has a documented history with federal prosecutors that dates back to at least 2009, a cooperation history that anyone who has been paying attention to this family's legal past already knew about, and that the streets of Memphis absolutely remember. DJ Academic surfacing that photo during the chaos of this past week hit the internet like a gut punch because of what it implies about the father, because that 11-year-old was not wearing an ankle monitor in a vacuum. He was wearing it in a world his father built around him, a world where legal entanglement was normalized, where the streets and the music and the legal system were all woven together into a single fabric. And now that fabric has produced a federal kidnapping case where the son is in custody and the father is on house arrest, and a courthouse clip that nobody who knows this family found surprising. It's like riding a bike. That lands differently now, because the same man who was there when the bike was first learned is now the man on the other side of the bond hearing. The same man who allegedly printed the paper and rented the cars is now at home, while his son watches the case unfold from inside a federal facility. And the clip of what happened when they were in the same building, in that courthouse, is the internet's way of trying to make sense of a betrayal that no legal filing fully captures. The bond disparity between father and son, in the context of Williams Sr.'s documented cooperation history and his alleged central role in organizing the operation, is the engine underneath every reaction video, every comment section explosion, and every reshare of that courthouse footage. The streets are not reacting to a legal technicality. They are reacting to the image of a son who followed his father to Dallas and came back alone. The Department of Justice walked to that podium with a case that sounded airtight. 9 defendants, electronic monitoring data, rental car records, fingerprints on Solo cups, surveillance footage, social media posts of stolen jewelry, a Staples receipt. The U.S. Attorney for the Northern District of Texas, Ryan Rabel, listed the evidence with the calm confidence of a man who believed he had built something that would hold. And then, within days of that press conference, 3 revelations emerged that have changed the way anyone paying close attention is looking at this case. 3 things that the DOJ did not mention at the podium. 3 things that Pooh Shiesty's defense team, Big 30's defense team, and every legal commentator who has looked at this closely since has latched onto immediately. The first one hit like a truck. Gucci Mane, the alleged victim at the center of this entire case, the man identified in the criminal complaint as RD, the man the DOJ said helped identify the suspects, has publicly stated that he is not cooperating with the federal government. And Fox 13's reporting from the courthouse made it even more explicit. An FBI agent testified in court that he had not heard from Gucci Mane, the government's own witness, the person whose account of what happened inside that recording room on January 10th forms the bedrock of the prosecution's narrative, has publicly walked away from that cooperation. Let that breathe for a second. The entirety of the snitching debate that has consumed the hip-hop internet for the past 2 weeks, the Joe Budden arguments, the Gucci's own no police clip circulation, the comment section wars, was predicated on the assumption that Gucci Mane had cooperated with investigators. And now the man himself is saying publicly that he has not, and an FBI agent is backing that up in open court. This does not mean there is no case. It does not mean the evidence disappears. But the single most damaging potential witness in this entire proceeding The person who could take the stand and point across a federal courtroom at Lontrell Williams Jr. and say that is the man who put a gun to my head, has, as of right now, declined to play that role. The second revelation came from inside the studio itself. Fox 13's reporting from the bond hearing also confirmed something that the DOJ's press conference had not addressed. There were no working video cameras inside the Rye recording studio at the time of the alleged incident. No interior surveillance footage, none. The prosecution has surveillance from outside the building, showing defendants entering, showing Williams Sr. on his phone, showing the group moving through the lobby. But what allegedly happened inside those recording rooms? In the control room, in the space where the AK-style pistol allegedly came out and the contract was allegedly signed, none of that was captured on camera. In a federal case where every other piece of evidence is either electronic data, physical records, or social media posts, the absence of any interior footage of the actual alleged crime is not a minor footnote. It is the center of the courtroom battle that is coming. Charleston White, correctly identifying that the federal government builds its cases frame by frame, rewinding every camera they can find. The problem is what happens when the most important camera, the one inside the room where the alleged crime occurred, was never rolling. And then came the third revelation, the one that Big 30's legal team has moved most aggressively on. In court proceedings, an FBI agent reportedly testified that surveillance and available evidence did not show Pooh Shiesty or Big 30 personally in possession of firearms during the alleged incident. The complaint identifies other co-defendants as the individuals who allegedly displayed weapons in the control room. The AK-style pistol attributed to Williams Jr. in the complaint is central to the prosecution's narrative. But if the government's own agent is acknowledging on the record that the physical evidence does not directly corroborate that specific claim, the firearms enhancement that would be the most aggravating sentencing factor in this entire case becomes significantly harder to prove. Big 30's attorney, Arthur Horn, heard all of this and moved immediately. Horn secured Big 30 a $100,000 bond with standard conditions, curfew, ankle monitor, and has already announced plans to appeal the judge's decision and seek another detention hearing in Texas. His argument, stated plainly, Big 30 has no personal stake in whether Pooh Shiesty had a recording contract with 1017 or not. They are music partners. They were going to make music together regardless of what label Shiesty was on. Horn's framing positions Big 30 not as a co-conspirator in a kidnapping conspiracy, but as a man who was present in a situation that had nothing to do with him, whose involvement, if any, may amount to something far less than the federal kidnapping charges he is currently facing. The legal architecture of this case, presented so confidently at that DOJ press conference, is already being stress-tested at every point where it can be contested. No cooperation from the primary victim, no interior camera footage, no direct evidence of firearms possession by the two most prominent defendants. And one of those defendants has already secured bond, is appealing for another hearing, and has an attorney who is telling the press his client has nothing to do with the central dispute that allegedly motivated the whole alleged crime. This does not mean Pooh Shiesty walks. The ankle monitor data, the rental car records, the Staples receipt, the cell phone placement evidence, all of that still exists and still puts him at every location prosecutors say he was. The charges, conspiracy to commit kidnapping, and armed robbery, carry a maximum of life in prison. And the aggravating factor of allegedly committing a federal offense while on home confinement from a prior conviction is not going away. And then there is the social media evidence, which no defense attorney can simply argue away. They posted it within hours on their own accounts. That digital paper trail combined with Greyhound bus records confirming the group's retreat from Dallas to Memphis the following day represents the kind of evidence that juries find viscerally persuasive, because it speaks not just to what allegedly happened, but to how the defendants felt about it afterward. What the three cracking revelations do mean is that the trial ahead, if this goes to trial, is going to be a real fight with no guaranteed outcome. And Pooh Shiesty, according to Charleston White, did not show up to that fight with an ordinary lawyer. Charleston White does not change his opinion about people easily. He has spent years on the internet being one of the most deliberately provocative, consistently contrarian voices in hip-hop commentary. A man who has built his platform on saying exactly what no one else in the room is willing to say, regardless of how it lands. And when Charleston White looks at Pooh Shiesty's situation as it stands right now and says he has changed his mind, that carries a particular weight, because changing his mind is not something he does for optics. Brave. That is the word Charleston White reaches for. Not reckless, not stupid, not self. Destructive, which is the word most of the more conventional hip-hop commentary has been reaching for since the arrest. Brave. And the framework he builds around that word is one of the more unexpected and genuinely interesting cultural analyses to emerge from this entire saga. Because he is not just defending Pooh Shiesty, he is placing him inside a historical lineage that most people would have considered absurd if they heard it a month ago. Huey P. Newton and Bobby Seale, Tookie Williams and Raymond Washington. Charleston White is not reaching for comparisons casually here. He is drawing a specific kind of lineage, men who were considered criminals and dangerous by the institutions that pursued them, who were later re-evaluated by culture as figures of a different kind of significance, men whose actions, whatever you think of them morally or legally, represented a particular kind of commitment and courage that could not be easily dismissed. He is saying that Pooh Shiesty and Big 30 represent something in the Memphis and broader southern rap landscape that is bigger than two men facing federal charges. Whether you agree with that framing or not, and reasonable people absolutely disagree, it is worth understanding why it is resonating, because it speaks to a deeper conversation the hip-hop community is having right now about power, about contracts, about whether an artist who felt trapped in a deal had any legitimate recourse, and about what it means when the system that prosecutes you is the same system that enabled the conditions that led you there. Charleston White's prediction about the legal outcome is rooted in something specific: the lawyer. Pooh Shiesty retained Brian Steele, a Dallas-based defense attorney whose reputation in federal criminal defense circles is, by any measure, extraordinary. White's claim about Steele is not hyperbole invented for content. A lawyer who has never lost in federal court on cases of this scale. That is the man Pooh Shiesty has in his corner as this case moves through the Northern District of Texas. And when you layer that alongside the three cracks that have already appeared in the prosecution's case, no victim cooperation, no interior footage, no direct firearms evidence on the primary defendants, you begin to understand why Charleston White, who arrived at this story expecting to say lock them up, is now saying something very different. The Tupac comparison is not about music. It is about trajectory. It is about what happens to a figure when legal persecution, whether or not the underlying charges are valid, elevates their status in the culture rather than diminishing it. Tupac's most iconic creative period coincided with his legal battles. His mythology grew in direct proportion to the opposition the system mounted against him. Charleston White is saying he sees the same dynamic forming around Pooh Shiesty, that the federal case, the father's involvement, the alleged contract dispute with the label boss, the ankle monitor data, the 9 defendants, all of it is constructing a narrative that will make Pooh Shiesty larger, not smaller, regardless of how the legal proceedings conclude. And sitting at the center of all of that mythology, misunderstood, complicated, and legally the most precarious, is the father. Lontrell Williams Sr., known as Mob Boss, built his identity in South Memphis around the same principles that shaped his son's music: loyalty, street credibility, the idea that family is everything and that you protect your own at any cost. He introduced Pooh to recording studios as a child. He taught him how to set up microphones. He ran Mob Ties Records. He was, by every account from people who know the family, not a distant or absent figure. He was present, involved, mentoring, shaping. Pooh has spoken about his father not as a parent in the conventional sense, but as an OG, a big brother, the person who showed him how to channel pain into music and how to move in the world he was born into. And now that same father is the person the federal government has sitting on the most combustible pile of evidence in this entire case. the person who allegedly made all the logistical calls, who drove to Staples, who rented the vehicles, who called the studio, who was seen arguing with his son at the back door 4 minutes before the alleged takeover began. The person whose cooperation history the internet has turned into the snitching narrative, even without a single piece of verified footage of any courtroom confrontation. The person who is on house arrest with a $250,000 bond while his son sits in federal custody. Charleston White's read on the father is the most unsparing part of his entire commentary. If the government is going to make an example of anyone in this case, it should be the man who allegedly left his son in the lead position while playing the background role of architect. A son who may have been convinced by the man W, who raised him by the man who built his entire understanding of loyalty and family and what it means to hold your ground, that this was the right move, that this was how you handle a situation when the legal channels have failed you and the label boss won't let you go. Charleston's words pointed directly at the father. He had no business leaving his son in that charge. And his take on Big 30's odds in the same breath is equally pointed. Big 30, who allegedly barricaded the door, but whom the Fed's own testimony suggests did not personally handle a firearm, has a $100,000 bond, an attorney ready to appeal, and a Charleston White endorsement for beating the case, or at minimum serving minimal time. Whether that prediction proves accurate will depend heavily on what comes out in the discovery process, and on whether the no interior cameras and no direct gun evidence revelations hold up as the prosecution builds its evidentiary case further. Whether that is fair, whether it accounts for the full complexity of a relationship between two adults who both allegedly chose to make this trip from Memphis to Dallas, is a question this case will not answer. Federal courts do not traffic in the nuances of generational trauma and street mentorship. They traffic in charges, evidence, and sentencing guidelines. And on that terrain, the father's paper trail is significant. His cooperation history is documented, and his position on house arrest while his son awaits trial is a fact that the internet will continue to read its own meaning into, regardless of what any verified footage shows or does not show. As of early April 2026, Pooh Shiesty remains in federal custody. Big 30 is on house arrest with an appeal pending. Lontrell Williams Sr. has been ordered back to Dallas. The case is in its earliest stages. No trial date, no plea agreements announced, no resolution anywhere on the horizon. Brian Steele has never lost. Gucci Mane says he is not cooperating. The cameras inside the studio were not working. And the Fed's own agent said the guns are harder to prove than the press conference suggested.